All right, people in the state of Michigan versus Dean Allen Lindblom, 237528 SM and 227148 SM. Mr. Lindblom appears via video Zoom from the Dickinson County Jail. He does not have an attorney in either of these matters momentarily. The prosecution is here through Assistant Prosecutor Emily Gunville. In 7148, the Probation Department appears through Probation Officer Trish Miller. Concerning these matters, and Mr. Lindblom, can you hear me all right? All right, Mr. Lindblom is choosing again, I guess this week, to acknowledge by shaking his head in the affirmative. The record should reflect. Mr. Lindblom, I'm going to ask you again today, are you intending to only shake your head in response, yes or no today, or are you going to verbalize? Are you going to shake your head yet? Will you answer aloud? Let me ask you that, yes or no? You'll answer aloud today? No. All right. Record should reflect in response to the court's question. He has moved his head back and forth in a manner indicating no, he will not be answering aloud today. I see in the courtroom Mr. Lindblom's mother is present. Hello, Mrs. Lindblom. In regard to last week's hearings, I think I saw Mr. Lindblom twice last week. We're here today on a probation violation as well as a pretrial on the original case as a disorderly disturbing. I described for the record last week the nature of the charge in that case of the disturbing the peace was on or about July 28th. It states in the probable cause portion, while the officer was on patrol in his vehicle, defendant rushed the squad car and yelled obscenities. He was taken into custody. I'm not sure what exactly happened, but there's another felony charge pending for assault on a prison or on the jail guard. That is pending. I arraigned him on that last week. He met with CAFA counsel, declined to have a lawyer, declined to verbalize or articulate any response when I called that matter for an arraignment. We also arraigned him last week on a probation violation concerning the assaultive behavior and the disorderly conduct charge. That's what we're set for hearing on today. In the afternoon, when the matter came back after CAFA counsel met with him on the probation violations, likewise, Mr. Lindblom declined to articulate, would rather only nod his head or shake his head in response. I considered it a nonverbal assertion similar to that under the hearsay rule, in that he was responding to the court in a fashion of yes or no, but he would not articulate a response. I asked the magistrate last week when she arraigned him initially on the 28th for the disorderly, whether or not Mr. Lindblom articulated that day. She indicated he, yes, was articulate and responded aloud on that Friday, the 28th, when he was arraigned on the underlying charge. So, Mr. Lindblom, in respect to today's hearings, are you choosing to proceed without lawyers, or are you asking that you be considered? Are you choosing to proceed without a lawyer today? All right, in respect to the matters, I told Mr. Lindblom last week that I had some severe concerns that there is no way he can conduct a jury trial or represent himself if he's not willing to articulate or use his voice. That one, the court does not and will not put up with that. Two, there's no way a jury would ever put up with that. There's no way to cross-examine anybody or act as your own lawyer if you're not willing to use your voice. So basically, at this point, I consider Mr. Lindblom incapable of representing himself. As I look at the progression of this case since last year when I had Mr. Lindblom and sentenced him in February of this year on this domestic violence, At the time, Mr. Lindblom was a traveling certified nurse's aide. He was articulate. He was participating in his defense. He was on probation. He was doing fine on probation. What has changed that made him respond and behave the way he did as contained in the allegations for July? Between then and now, I really am not sure, but as I told him last week, ma'am, and as I'm saying again today, I have some serious concerns regarding his mental health. I told Mr. Lindblom I was sure that his family, who was very supportive of him, would as well have some serious concerns regarding his mental health, because this is not the same man that I saw before me 6 months, a year ago. So I don't know what's going on. Ms. Gunville, do you have any other information you can share with the court? Because at this point, I do feel that I have a sua sponte responsibility to have him evaluated for purposes of competency. Do you have any other information?
No, Your Honor, though, we were just waiting for the pretrial. He hasn't received the police report yet. Waiting for the pretrial to see if he was going to retain counsel or if he was going to get counsel. I do have a copy of the police report that I will get over to him right away after this. And I know Ms. Cass is working on the other file in the felony matter, but I would concur that I think that something needs to be done in way of competency and have a mental health assessment, Your Honor.
All right, thank you. Is there anything you'd like to share with me today, Mrs. Lindblom? You don't have to.
No, that's okay. I would like to.
I mean, I don't want you to talk about I'm talking about his mental health right now, whether or not I should have him evaluated, because he doesn't seem like the same man.
What I would like for him.
All right, for the record, this is Mr. Lindblom's mother, Judy Lindblom.
I have been through everything with him. And I would like to have him evaluated somewhere. He's very angry. There are things that have happened, if I could explain them anytime.
Well, I think best.
No, I don't want to go that far.
Yeah.
Okay, so I would like him evaluated, but not drugged up.
I see. Well, right now, nobody's going to be drugging him, but we are going to have him evaluated.
Okay.
All right.
Can
I'm going to make the referrals. Okay, and on the felony matter as well, Miss Carrie, if you could pull the felony file. I am going to make referrals based on the record that I've created here. And in the misdemeanor file, the new one, which is 237528 SM, as well as the pending probation violation in 227148. Well, there's several of them. The probation violations. I want him evaluated for purposes of competency to stand trial. In respect to the felony matter, I want him evaluated for both competency and criminal responsibility. Mr. Lindblom, in the meantime, I'm going to put your hearings on hold. If you change your mind and you want a lawyer in the meantime, you fill out a request at the jail and we'll get you a lawyer. We'll make the referral over to Michigan Indigent Defense Commission, and they'll make a decision about whether you qualify. Otherwise, what's going to happen is you're going to get evaluated for purposes of competency and criminal responsibility. In the meantime, concerning, let me look at the bonds in these matters. All right, I set bond in the probation violation at 5,000 cash surety, 10%. And in the felony matter bond,
$250,000 cash, surety, 10%.
All right, the bond on the felony matter is 250 cash surety, 10%. And I believe in 7528, the misdemeanor, it's a personal recognizance bond.
250,000 in the felony.
I said in the misdemeanor file, it is a $500 PR bond. In the felony, it's a $250,000 cash surety, 10%. I said that. All right, then, in regard to the matter, the bonds are in place. I'm ordering the evaluations. If your office could prepare those, I would be most appreciative. And then send them over for signature. So he'll be evaluated at the Center for Forensic Psychiatry. Mr. Lindboom, as soon as there is an opening, in the meantime, is there anything else you wanted to address today, Mr. Lindboom? No, all right, he's shaking his head no, thank you, sir. All right, anything else, Miss Gunville?
No, Your Honor, thank you.
All right, then, thank you, Ms. Lindboom, good luck.